Lordship, item number 3.
Yes.
Yes, I prefer some time, Your Lordship. Actually, due to my family problem, I could not prepare it. So I just need a bit time. In 2 weeks' time, maybe.
How long?
2 weeks' time.
On pre-made by the petitioner, this is matter up to 2 weeks.
Oblige.
From supplement cost list, item number 1.
Lordship, in this matter, the respondent has filed their affidavit, Your Lordship. I'm not sure whether they have placed it before, Your Lordship. Whether they have filed it in the registry.
So you'll file your counter?
I will file my rejoinder, Your Lordship. Yes, Lordship, accordingly.
And a counsel for the petitioner has submitted that the counter affidavit filed by the respondent by the state respondent number 1 to 4 has been received. It is prayed that some more time may be allowed for the rejoinder to be filed.
Yes, Your Lordship.
Pray allowed. This is matter. When is the
After 2 weeks, Your Lordship, along with the other matters.
This matter up to 2 weeks. Islam kita kiyo.
Oblige.
Item number 2.
Mr. Sangreso,
My lord.
I'm very sorry. See what happened yesterday, I dictated the order in
Yes.
court. When I went to chamber and checked, there appears to be some confusion. Because when I went through your petition, you made a reference to Respondent 7, Respondent 4.
Yes.
But if you look at your course title,
Yes.
those respondents have already been struck off.
The course title.
Yeah. Look at the height of our course title.
My lord, page number 2 onwards. The respondent.
4 to 6.
First, look at your course title.
Right.
See, respondent 4, 5, 7, 8, 9, 10 have been struck off.
Yes. Yes. It's 6,
So,
11 to approve.
Yeah, by this order 27/5/2024.
Right.
Now, in your correction,
Right.
you have struck off respondent 7
Yes.
and inserted number 4.
Yes.
But number 4 is already struck off.
My lord, I think my learned friend, after removing the those respondents, he has changed the number, my lord.
How can it be?
That is not, my lord.
I have a suggestion, my lord. Your lordship had passed the order yesterday, remanding the matter to this council on the basis of the application filed by them. The writ petition can be disposed of. If they are aggrieved, later on they can come with a liberty to file afresh. Otherwise, my lord, this is all confusion and there are so many additional affidavits which have also been filed in the writ petition, which would make it difficult. Liberty will be given to them or to them.
I think, Mr. Sangus, that would be best.
Yes, that would be the best course.
Right now, as of now, I don't have instruction to, my lord, to concede
As
that-
Mr.
that
Dindo
point.
had said, you see, it is logical. It is logical. You have made a representation. Notice has been issued to you. So let that process be over.
Yes.
So, as and when it is over, as has been pointed
Yes,
out in
yes,
the,
Your
as
Lordship,
I have dictated the order also,
Yes, please.
any outcome of the of the process between before the district council
My lord,
is subject
Either
to
parties
that
can.
is always there, but since the lordship parties are already before this court, and lordship has allowed us to cure some defect earlier occasion.
but
And these are the minor one.
But under this, now it appears, you see, that is why like I said, I have not gone through the petition as such, and even your correction. So confusion would definitely, arise. In course of proceedings, something might come up.
I understand the suggestion made by the special senior counsel, However, my lord, with regard to these defects, my lord, if lordship permits me, today itself my colleague will cure the defect itself. Is there only numbering? Otherwise, lordship has a vast.
It has become too, too hodgepodge.
My lord, my junior colleague will retain the same serial number. 11, 12 will remain the same. 6 will remain the same. Instead of number 4. So instead of number 4, she would insert number 6.
Yeah, 6, yes.
Yes, only that.
My lord, what is going to happen after the district council passes the order? Suppose it's in their favor, well and good. Suppose it's not, he'll still have to withdraw this and amend the writ petition. It comes to the same thing.
That is my side or my friend's side. Every party has the right.
Any aggrieved party would.
Any of the parties.
But since lordship has seized the matter, only 2 weeks time, my yesterday lordship has passed the order, and let the district council
True.
take a decision also. But then we have no grievance.
Mr. Krim, you're appearing for this cordon Shala.
Yes, sir. Number 6.
But then, earlier you said you're appearing for Respondent 4.
Your Lordship, they have changed to number 4. Number 4 is, now when they all delete that, that becomes number 4, Lordship.
So, my lord, I can change it to number
Yeah,
6,
change
my lord,
again.
if lordship suggested.
Oh, yes, now I can see again.
Normally we can do that also, but since the registry raised some objection,
Like amendment, the whole petition, Lordship. Even the nature of the.
how can it be numbering of the party will not change the character of the.
We will not change, but like I said, see, it has become too. It doesn't look.
And the impinged order also has come by way of an additional affidavit.
It looks like a correction in an answer sheet, where you cross and you.
With lordship permission and with presence of the registry, we do.
Yes.
I consider that my junior colleague has committed some mistakes.
Again,
She
you see,
retain the same number.
you still have to consider. Fine, there's an order that has been passed, wherein these respondents 4, 5, 7, 8, 9, and 10 have been deleted.
Struck.
Now, if it is required to change the whole structure, in as much as what Mr. Kriam said, it comes now. The renumbering would be 1, 2, 3. Instead of 6, it would be 4.
But that is the way my junior has corrected.
But here it is not so. Here it still remains 6.
So therefore the registry.
So then 6. Then this Kharim sameship would be 7.
Yes,
5 and 6.
it will become 5 and 6.
Of yes 5.
5 and 6.
Then Bakraur of Raj non-Krim becomes 6. So the only 6 responded.
Before the 6.
Yes.
So that has to be done.
So we will do it immediately, my lord. Today is heavy lordship.
Ni tukar order mo order. Copy ni tukar order. Pass me. Agak sistem lucu.
I think the first part of the order has to be changed. Because in the first part of the order, Your Lordship, yesterday
I've
had.
forgotten what the second part had.
The second part was regarding the district council remanding back the matter. But the first part is that the necessary correction has been done.
Toh, try. Katuka agak sistem kurang dan betul kan? Api kurang dan ni. Ha? Betul kan? Kita itu muka dan ni. Heard the council of the parties. This matter has come up on for clarification of the clarification on the part of the petitioner as far as the correction of the correction made in the body of the petition, including the cause title, wherein some of the respondents have been struck off, necessitating correction of relevant amendments in the body of the petition. However, since this court has allowed the correction to be made manually and has not insisted for a fresh amended petition to be filed, confusion has arisen as far as the said corrected portions are concerned, which does not appear to tally with the corresponding names in the cause title. However, Mr. H.L. Sangreso, learned senior counsel appearing for the petitioners, has submitted that the error was on the part of the learned counsel for the petitioner, who has failed to make necessary correction as far as the cause title is concerned. For example, where the name of respondent 6 appears as respondent 6 in the original cause title, the same should read as respondent number 4. And so on and so forth. If such correction is made in the cause title, the issue would have been resolved. Further submits the learned senior counsel. This court, on consideration of the submission made, and on the assurance of the learned senior counsel for the petitioner, would allow the necessary correction to be made. Since all the relevant respondents are before the court today, the correction made would be done so in their presence. I think we can do that then. We'll just cut off this 6 and, instead of 6 it will be 4.
Yes.
You can do that.
In our petition it has been done. They have done it, but they forgot to do it in the courts.
So sorry.
Okay, I'll do it. So you pay me the fees for this.
A part of the fee.
So 4, 5 and 6. The second part of the order I'll dictate in chamber.
Yes.
So that date will remain the same after 2 weeks.
Much obliged.
Thank you.
Item number 9.
May I please, Your Lordship, if you kindly take up this matter at the end of the board, Your Lordship, as Mr. S.J. is
Hearing matter will take it at the end of the board.
much obliged.
Done orders.
From daily list, item number 1.
Please, Lordship. Lordship, in this matter, we are required to file this miscellaneous, Your Lordship, application, Your Lordship, regard to some development in this matter. So, Your Lordship, we couldn't be able to file, Your Lordship, so we are praying some more time, Your Lordship, to file it.
You want to file a petition or you have filed?
No, Your Lordship, we haven't filed, Your Lordship.
What are the developments?
There are some development, Your Lordship.
What are the developments? Tell me.
Some order has been passed, Your Lordship, so I have to bring that development to court.
What order?
If Your Lordship give us 1 week's time, Your Lordship,
Are you aware of this development?
Lordship, this case
Lordship, the Lordship will recollect this is regarding the power of Darbashna.
Yes, so what are oh yes, I think last time you said some order has been passed by Darbashno.
Some order was passed, and then the power of Darbashna, KCDC, and it's serious legal issues involved, Your Lordship. Lordship had heard it at length, and then Lordship said without hearing the.
This is basically an issue of jurisdiction, isn't it?
Absolutely, Lordship. And Lordship also realized the gravity that without hearing the Darbar
Yes.
and the KCDC.
But they have chosen to.
They are the very important stakeholder.
But they have chosen to stay away from the proceedings.
Yes, Lordship. It's very unfortunate. They should
Matter
have
will
come.
proceed ex parte against them.
Yes.
Because they take up whatever is in record. If it favors them, well and good. If not,
Absolutely. Because Lordship is not the issue of one Darbar even only. As Lordship rightly says, jurisdictions is going to have a far-reaching effect. So that's why Lordship time and again whenever the matter was adjourned, Lordship was very lenient in granting
yes,
time.
yes. Now,
Because Lordship wanted to hear the matter when all the parties are there and all the issues are brought together. So they'll be easy for the court also to take a view. And we also don't want ex-party Lordship, otherwise they'll come and again recall, withdraw, and then what's the point of having such a detailed hearing? So that's why Lordship is given. Lordship, you see the order sheet, Lordship is given ample times to everybody.
that,
Even after hearing, there was an issue raised, then Lordship is granted. Lordship, but if they want some time, Lordship, we have got no objection. But let them come with some. If they have some problem, they can come with.
Mr. Learned Counsel for the petitioner has submitted that there has been certain recent developments which would affect the interest of the petitioner. Development which would affect the petitioner, and as such, it is prayed that an application may be allowed to be filed in this regard to bring such developments to the notice of this court. On such prayer not being objected to by the respondents present before the court, the same is allowed that the petition be filed with advance copy to the respondent, who shall file the response if so desired,
Not
instead of waiting for another date, for response to be filed.
absolutely, absolutely.
This is matter to 3 weeks.
Item number 2.
May I please, Your Lordship, I humbly pray that this matter be taken next week, Your Lordship, as Mr. SD is unlike in courtroom 2, Your Lordship.
What is this matter?
This is regarding.
Appointment of a Gauru lecturer,
Oh,
Lordship,
that-
for that.
Your Lordship.
It has been heard. Has it been heard?
Heard, but not at length. It has been heard. The petitioner's side has been heard.
Okay. So end of the vote.
Next week, Your Lordship.
Next week.
And the last order also may be read, Your Lordship.
Yes. Then there's no escape for you. Yes, 2017 matter.
Yes, Your Lordship.
Yes, Miss, I think you take up the matter.
Yes, Your Lordship.
You take up the matter.
I'm
here.
not that much be in opposition, Your Lordship.
Why?
because
Yeah.
Sir SD is arguing this matter, Your Lordship.
But he is here in the court, isn't it?
Yes, Your Lordship, he's in courtroom 2, Your Lordship. He have one matter.
So we'll wait then. End of the vote. What we can do, Mr. Karim, we'll finish with the argument of the petitioner. If response is required from you, in the meantime, if we have time, we'll also hear the other respondents. If response is required from you, then we can fix it.
It's very much required from him. It's MPSC, Your Lordship.
So are you the MPSC?
Your Lordship, Monday, tomorrow I have some personal difficulty.
When the matter came up for hearing, the learned counsel for the petitioner has sought for accommodation on grounds of personal difficulty. Similarly, Mr. B. Graham, learned counsel for the 4. 3 to you are 4 or 3 to 5? Who's 3?
3, 4, and 5. 3, 4, and 5.
Respondent 3 to 5 has also sought accommodation on ground of personal difficulty. Though this court has made it clear that though this court in its previous order dated 10/7/2024 has made it clear that no further adjournment will be allowed in this case, in view of the submission made, the prayer is allowed. This matter is accordingly adjourned, subject to payment of costs by the respondent, by the petitioner, as well as the respondent 3 to 5 of rupees 1,000 each, to be paid in favor of the Shillong Bar Association. This is matter after 1 week.
Your Lordship.
Item number 4.
Yes.
In this case, it needs some accommodation, Your Lordship. Not in a position to discuss.
Just a moment. Who's appearing for the petitioner?
Yes, Congress.
Where's Mr.? He was here just. You're supposed to contact this one. So what happened?
Your Lordship, I was not in a position to contact. Earlier, this officer, Nanam, is there, and I have to go personally and meet to them. I have to explain to them. So I was not in a position to go personally. Because officer was fit to go, and I was not in a position to make the accommodation.
Mr. R. Deputy Learned Counsel, Learned CGC, who has earlier appeared on behalf of the respondents 4 and 5, and has since disengaged himself from appearing for such respondent, has submitted that he could not personally, he was able to personally contact the respondents 4 and 5 to inform them of the change circumstances. It is also noticed that this court, in its previous order dated 10/7/2024, has noted that the petitioner has affected notice upon the respondent 4 and 5, but such respondents have failed to appear for this court. So we'll proceed ex parte then.
Well, and fix
Nothing can be done.
accordingly.
Notice have been affected, isn't
They're
it?
affected already. They are very much aware. They are very much aware.
Accordingly, this matter shall proceed ex parte against the respondent 4 and 5 respectively. So we'll proceed with the hearing.
Well, after 3 weeks to 2 weeks.
Not today.
But since today is, I expected the report from the CJC.
On prayer made by the petitioner, this is matter is also for hearing.
It is also for hearing.
This is matter for final hearing
Yes.
after 2 weeks.
Deeply obliged.
Item number 5.
Yes, Lordship. This matter was heard at length. Actually, in fact, we have concluded the hearing, but only thing is that whether one aspect of the matter is regarding the termination order, which was issued subsequently after while the pending of the repetition. Now, Lordship has asked on the last occasion. No, let me just complete. Then they can make a submission, because during my submission, if they contradict, then I'm not going to say anything against them. But let me complete, then they also know the whole fact what I'm trying to say. Because in the meantime, number submission before this is, we are coming here to the court for justice. It is not just we just finish the case or it is just no case. My what I'm trying to submit here is, Lordship, that I'm praying that I may be allowed just to amend my petition. Or yes,
yeah, that's what I was
challenging since.
Mr. Sangma,
Lordship.
What is your initial prayer?
My initial prayer was that because the release order, it's amount to termination order. The release order, they have given a release order saying that debarring me from continuing in my service. After issuing the release order, they have not allowed me to continue in service. They have not given this one. They don't allow me to continue in service. Then it's amount to termination, and that release order was done without approval of the competent authority. The law is there. I have made earlier occasion. Otherwise, also, my lord, I have stated that it is the fact that I was terminated, but that termination letter was never punished. It is not the case that if that termination has been made prior to, I should have enclosed it in the other initial pleading and my petition. I could have my pleading should have been, but then since they have never punished, it is on record. Now even I should humbly submit that they are not. They also have not able to produce and establish the case that they have punished the copy of the termination letter. But termination letter I got only from the affidavit filed by my learned friend from the government. Initially, the private respondent, those managing committee, they have opted not to file the affidavit, and the final stage court has given an order. Then they have filed it. Then thereafter, I have filed a rejoinder. Otherwise, my lord, I have in my rejoinder I have clearly stated that they have neither punished the impugned termination order, nor this was done in as per the law. That was there.
See, Mr. Sangma, in due course,
yes,
that termination order,
yes,
has been brought to your notice.
Yes, Lordship.
By way of the affidavit.
Lordship.
So have you filed a rejoinder to that?
Yes, Lordship. In the rejoinder, I have denied that this never we clearly stated. It is there also, Lordship. I have make a mention that termination letter was never issued, and even if that issue, I have mentioned very categorically in my termination letter, my lord. In my rejoinder, my lord. It is in my rejoinder, if your lordship is there. I have filed it very detailed rejoinder to the affidavit filed by both the consul in para. My rejoinder, lordship. Para 4, this one, page 4, para 4 and 5.
Just a moment.
Sub.
Page 4.
Page 4, this sub para 4, 5, 6, 7. 7 I have mentioned. May I read, your lordship?
Yeah.
The managing committee, that is the respondent number 5 and 6, have released the petitioner from her service as an assistant teacher with effect from 15/02/2019, and the said release order dated so and so is under challenge by the instant repetition. But the alleged termination order dated 25/01/2020 issued by the managing committee was never supplied and punished to the petitioner till death. Therefore, due to non-supply of the document, that is the termination order, petitioner was not unable to challenge against the termination order dated so and so. It is stated that the petitioner strongly denied of receiving the alleged termination order dated so and so, and the said challenge impugned termination letter was enclosed by the state respondent only after 1 year when they file an affidavit in opposition in respect of the writ petition filed by the writ petitioner, and hence no procedure had been followed by the respondent authority while
during the pendency of the writ petition termination order is issued. That is absolutely incorrect, my lord. My lord will kindly peruse the record.
Termination order is dated 25/1/2020.
My lord. And when is the writ petition filed, my lord? In 2021.
He says that he has.
No, my lord,
he has not
assuming that
received- the petitioner has not received the
yes,
termination, this order.
yes,
So that is the question to be answered.
So, my lord, even assuming what my friend is saying is correct. So, my lord, when the moment we filed an affidavit bringing this on record, my lord, what remains, my lord, in the writ petition? Unless you are challenging the termination order, what remains? No, even if on the last occasion also I stated, my lord.
See, this Aberman would say so, that he is challenging your termination order in the sense that
Lord,
he is saying that he has not received it. So there was no process.
yes.
There was no process
if
as far as issuance of this is concerned. So tell me.
My lord, this is for the managing committee, of course, but rightly or wrongly, my lord, a termination order is in place. Now, if anything is to be set aside and quashed, it is to be that termination order, my lord. Even assuming that if the release order is quashed, my lord, by this honorable court, the termination order still stays, my lord. What happens to the termination order?
We will deal with that termination order.
So, my lord, for that, my lord, if the writ petitioner ought to have withdrawn this writ petition, file a fresh writ petition, my lord.
Challenging because
since you have earlier, just now, you said that you want to amend this petition.
Lordship,
the prayer.
I don't want to take a risk because I just want to because of that only, because Lordship already pointed out, of course, it is the fact that they are not able to establish whether the termination letter was have been received by the petitioner. Therefore, I am saying that I may be just allowed to file the amendment petition to the effect to the termination letter.
The whole
it is not required to withdraw the entire
no,
matter.
my lord. Why, my lord? The whole case will change.
No, it will
Whatever
not change
submissions he made in the writ petition, all that will change, my lord. The facts and circumstances have changed.
No.
Have changed. How can my friend say that he will amend the writ
subject matter
petition?
is from removing the petitioner from service, because the release order itself is amount to the termination the same it will be the same, because this is same subject matter. The termination is arising out of the release order only. The main issue is because they have released me. I have challenged in the Autonomous Council election.
You are saying that the termination order is the consequence of the releasing order.
Lordship, yes, that is my statement.
That would be your statement.
That is my statement. Yes, they release me first, then termination.
It cannot be like that, my lord. He has to challenge the termination order.
No,
now even the annexure and the writ petition will change, my lord. Everything will change.
It is up to the court to decide.
Now he is proposing to challenge the though.
So
that fact is already on record now.
Yes.
The fact of the termination order is already on record. You have brought it by way of an affidavit.
My lord.
He has countered that by filing a writ order.
My lord, we have brought this on record in the year 2022, my lord, when we filed the affidavit. My lord, here the final hearing, everything is over. Now, my lord, now at this second, my friend is telling that he wants to amend the writ petition.
Now he also
the final hearing was concluded on the last occasion, my lord.
Now they are also asking me insist in file a press whether that is right.
See, Mr. Sawa, what you can do. There's no requirement for you to of course, since that is a pleading.
Lordship.
Then it has to reflect.
Yes.
It has to reflect in your
yes,
prayer.
yes. It is there, Lordship. Lordship can pass any order, Lordship.
See, prayer without pleading will not stand.
Yes.
And also, see, pleading without prayer,
Your Lordship.
will not stand in your case.
Lordship.
And allow him to amend the prayer.
Lordship.
Mr. P.D. Sangma, the counsel for the petitioner, has submitted that there is a strong challenge to the subsequent development brought to the notice of the petitioner as far as the vis-a-vis the alleged order of termination dated What is the date?
25.
My lord, the
25
Date of
January
the termination order?
2020.
termination order. My lord, termination order is
Termination order is in the
25.
affidavit
25
in opposition filed by the state respondent, my lord.
25/1/2020.
Yes, Lordship. 25/1/2020.
yes, my lord.
25/1, is it?
Correct.
Page 15 the affidavit filed by the state.
Yes, my lord. Page 15.
This termination was issued by the managing committee.
Yes.
Managing committee, then they allege that it was approved by the this one, by the
And thereafter approved also, my lord.
Where is the approval?
Approval order annexure 6.
My lord, approval order is the last, my lord, page 18, annexure 6.
Momentum vis-a-vis the issued by the headmaster Haripara SSA UP School, by which the petitioner, the service of the petitioner as teacher of the said assistant teacher of the said school has been terminated. Consequent to the said termination order, termination letter, the district mission coordinator SSA West Garo Hills by communication dated 2011-2020 has accepted the said resolution dated 25/1/2020, whereby the petitioner as assistant teacher was terminated. Next, it is the submission of the learned counsel for the petitioner that there is that the decision of the authorities concerned have not been intimated to her, and the same is known only when the counter affidavit was filed in this case. Although the petitioner has filed a rejoinder countering the averment made in this regard, it is however prayed that the prayer made in this petition be allowed to be amended to incorporate this issue.
Lord, sorry to interject, my lord. My lord, order of this honorable court dated 10/7/2024, my lord. My friend was supposed to bring some relevant authority.
That's why I'm making submission.
Now he's making
Yes,
a submission.
Yes, to that effect, I have already made my submission.
We'll do on. See, this will only form.
Yes.
See, we are not divesting from the main issue.
Lordship.
The main issue will be there. You have made your point. He has made. Now we'll see whether the process was correct or not, whether the law has been satisfied or not. Only to that extent. As far as opportunity for the parties to present their case is concerned, I think that's incumbent upon the court to.
Lordship.
Lord, as far as my submission with regard to the objection to the amendment, my lord, that may be kindly be recorded, my lord.
If he file the amended, he will be allowed to file the amended petition. You can respond if you want to. Accordingly,
We'll have to file a fresh affidavit again.
only with regard to that aspect.
Only that's what.
Mr. T.P. Bhattacharjee, Leonard G. appearing for the state respondent, as well as Ms. S. Bhattacharjee, Leonard Counsel appearing for the respondent managing committee. Mau gum tu, ti pusin mau mau un menu tu ka. Ka hadir tu ka bai, sekolah ka paragraph on consideration of the on consideration of the prayer made, the same is allowed. The petitioner is allowed to amend the prayer and to file the amended version of the petition on the next date fix. Next has also submitted that they may be allowed to respond to the amended petition to be filed by the petitioner. Prayer law. This is matter of the
3 weeks.
Why 3
2 weeks? 2 weeks, my lord. 2 weeks.
2 weeks.
Lordship. Masterless lordship.
Item number 6.
Your Lordship, in this case, I was supposed to file the written argument, Your Lordship. I was not in position to prepare.
Have you filed yours?
Yes.
I didn't prepare my
1 week, Lordship.
2 weeks. This week I'll be busy, Lordship.
Mr.
Very short point involved.
Mr. Artabda, Leonard CGC has submitted that he written argument on behalf of the response sometime for the same to be filed. On pre-made, the same is allowed. This is matter of 2 weeks.
Item number 7.
in this matter, my lord, the CBI has concluded the submissions, my lord, and I represent the accused number 1 and 2, my lord. The accused number 1 and 2, my lord. And before advancing my submissions, my lord, just two things that I wanted to point it out. The first thing that I wanted to point it out is that when the respondent number 4 and 5, this honorable court approached this honorable court, and this honorable court allowed to produce the documents that are in the custody of respondent number 4 and 5, my lord.
Yes.
By then, the charge sheet was already filed between in respect of and 3, who were the officials of the NEC, my lord. We 2 and 3 also came before my lord, and my lord has given me the benefit of the order that was given to respondent number 4 and 5, my lord. So therefore, the submissions met on the last date by the by the counsel of the CBI, that we a trial court, and the trial court allowed that that is factually incorrect and is beyond the records, my lord. Second point that I wanted to make, my lord, before I go into submission, just a summary, my lord. When the CBI opened to submit the points before my lord, they have fed my lord with all false and wrong informations, my lord. This is the first point that they fed my lord with the wrong information. The second point, they said in the 2000 there was an exchange of letter between the accused person. That is also incorrect, my lord, because by then.
No, but those are borne by records.
Those are borne by record, but are they saying R.P. Kharpuri and U.K. Mishra are the same and the one person? The letter of that exchange happened in 2010 are between U.K. Mishra and the college, not between R.P. Kharpuri. So they try to project that there was a conspiracy, there was a meeting of mine, and said, oh, we were caught now. How do we come out of this? Okay, I will write a letter to you, and you reply to me. And they projected in that way, saying that the accused person, one accused person writing, another accused person accepting.
To condone such.
To condone the act. So if they are saying R.P. Kharpuri and U.K. Mishra is the one and the same person, I have nothing to say. But they are not, my lord. They are not. The exchange of letter that happened is between U.K. Mishra and the college, my lord. So my intention on the wrong side, my lord. Now, my lord, CBI has invoked the revisional jurisdiction of this court, my lord. Now, what is the object of a revisional jurisdiction, my lord? The object is to set right what is patently defect or error of jurisdiction or of law. CBI has tried to point it out, something which is, they never said, and I have heard, my lord, when my lord said enough of the facts, what is exactly the object of jurisdiction of object of the revisional jurisdiction? When they say, when my lord poses the questions, what is the law? They sum up the submission and saying that we will submit with a citation, my lord. Which citation that never come till now, my lord. Which means that, my lord, they have nothing to say. Where is the patent defect in the judgment? Where is an error of jurisdiction? And where is the error of the basic and the fundamental object of a criminal revisional jurisdiction under section 397, my lord? And my lord, when we talk about the criminal jurisdiction, my lord knows the higher court has a very limited one and cannot be exercised in a routine manner, my lord. And for that, my lord, I would like to refer to Amit Kumar versus Ramesh Chanda, my lord, 2012-9-460. Paragraph 20, my lord.
Amit Kumar or Amit Kapoor?
Amit Kapoor, my lord, our Advocate General. We are so fond of our Advocate General.
Become his fan.
Amit Kapoor, my lord. Amit Kapoor versus Ramesh Chandar. I'll take my lord to paragraph 20 straight away. It's page 479. Page 479, my lord. My lord has got pen.
Yes.
May I read, my lord? Para 20. The jurisdiction of the court under section 397 can be exercised so as to examine the correctness, legality, or propriety of an order passed by the trials of law. The decision is completely erroneous or where the judicial discrimination is exercised arbitrarily. On the other hand, so this talks about 482, my lord. So therefore, so now in the last submissions, my lord, nowhere what the review petitioners were doing is choose some documents again which they have done before filing the charge sheet in the first instance. The same thing, before my lord also. They have not even shown, my lord, what was the reason. Because in the one of the order passed by my lord was that under what circumstances, or what is the view of the court coming to a conclusion and setting discharging all the accused person. That was supposed to be addressed, and that is supposed. This will take little time, because after we read this one, my lord, everything will come very clear, my lord. 188, my lord. That is the impugned judgment, the subject matter which is a review sought for a revision here, my lord. 80, my lord.
Para 80.
From para 80, my lord. I will not go what they say, what didn't say. Actually, my lord, they have taken out points which was never raised before the trial court also. But I will not go to that to burden my lord. This will suffice, my lord. Para 80. May I start reading from para 80? Yeah. Now, having heard the submission of the parties and perused the record of the case as well as the documents annexed to the above mentioned criminal revision petition and the documents produced 3, 4, and 5, it is seen that St. Peter's College submitted the project report to NEC on 8/2/2005. The said project report dated 8/2/2005 is available at page 16 to 24 of the revision petition. In the said project report dated 8/2/2005, it is stated that the said scheme had already been initiated at Arunachal Pradesh and make advance expenditure from the own source of the accused 4 and 5, and the same would be reimbursed in anticipation of NEC sanction. Which means before even this scheme was submitted, St. Peter's was already in the process of their own fund. And they were spending this in anticipation that if money is released, we will be utilizing it there. If not, then we carry on with our own money. This speaks like that, my lord. This is the observation of the court. The said project report was forwarded and recommended by the implementing agency, namely Director of Higher and Technical Education, Government of Meghalaya, Shillong, as required under the Procedural white letter dated 28/2/2005 at Annexure A1 to the rejoinder affidavit of the accused number 4 and 5 to the affidavit in opposition filed by the prosecution CBI. In the said forwarding letter of the implementing agency dated 28/02/2005, that is a letter of the Joint Director of Higher and Technical Education Meghalaya, Shillong, to the Director Northeastern Council, Shillong, it is clearly stated that the project report submitted by the principal of St. Peter's College, Shillong, was also enclosed therewith, which is self-explanatory, and NEC may kindly consider extending of financial support as per proposal submitted. The NEC under its order dated 18/3/2005 had accorded administrative approval for implementing of the scheme research-based holistic cluster approaches at grassroots level for sustainable development in NER by the St. Peter's College at a total cost of rupees 4,98,50,000. Only for a period of 3 years, and sanction is subject to the terms and conditions under which the project should be implemented as per the scheme submitted by St. Peter's College, Shillong. The copy of the said order dated is available at annexure. So this is the order, my lord. This is the order passed by then R.P. Kharpuri, my lord, the accused person number 2 here. That time he was the in-charge director S&T, NEC, my lord. Now, the 81, my lord. It is seen that NEC under its letter dated 29/8/2007, annexure 3 to the revision petition, congratulated all the members and the principal of St. Peter's College, Shillong, for research-based holistic to sustainable development in NER. The director S&T of the NEC under his letter dated 19/12/2008 to the principal of St. Peter's College, Shillong, that is accused number 4, disputed the purchase of the land at a cost of rupees 2 crore out of the sanctioned amount of rupees 2.67 crores was not part of the scheme. The director S&T under his letter dated 26/11/2008 directed the accused number 4 to clarify whether or not the purchase of the land was a part of the detailed project report submitted to the NEC. The said letter dated 19/12/2008 and 26/11/2008 are available at annexure B, that is at pages 19 and 20 of the rejoinder affidavit filed by the accused number 4 and 5. The accused number 4 under his letter dated 21/03/2009 to the director S&T NEC, Shillong clarified that under page 6 of the scheme under the head Holistic Cluster Approach Capacity Building, Training and IT Awareness, which is clearly states major component would entail infrastructure development of built-up space, land of adequate proportion. The purchase of the land is a component of the scheme, and if it is not acceptable, the petitioner agreed to adjust the cost of land procurement with other components under the scheme as their share of expenditure. Now, what did the CBI say? The CBI said that the scheme was given for project, and they took that money and they bought a land worth 2 crores rupees. They never said what was the observation, detailed observation. So this is the development, my lord. It's not as simple as that. I got 2 crores, 2.6 crores. I bought a land out of that, and I'm very happy. And for my personal use, they try to project to my lord. It is not, my lord. Now the accused number 4, I am continuing. The accused number 4 under his letter dated 06/5/2009 requested the director NEC Shillong to treat the said letter of the accused dated 21/3 drawn and may be treated as irrelevant, and detailed up to the reconciled statement of accounts will be submitted in due course. Can you look, my lord, here? This was before the charge sheet. This was in fact before filing of the case, lord. Subject to some clarification there, my lord. They've already saying that if it's not acceptable, please, we will give you a consolidated, we will submit a reconciled statement of accounts, will be submitted in due course. Next slide. The director at 25/05/2009 requested accused number 4 and 5 to furnish the detailed item-wise expenditure incurred under the various subheads, particularly with reference to upgradation of lab build-up space, special requirement, as well as capacity building, training, etc. Vis-a-vis the audited statements already submitted to the rejoinder. Again, the director S&T NEC requested the accused number 4 to furnish scheme-relevant supporting vouchers, etc., exclusively against NEC's grant component of rupees 2.67 crores and also up to date physical progress report of implementation and the list of beneficiaries. In response to the said letter of the director, the accused number 4 under his letter dated 27/6/2009 submitted accrual expenditure incurred specific NEC fund released to as far as rupees 67 lakhs towards R&D activities for which UC has already been submitted. 60 lakh for infrastructure development of labs, and 140 lakhs for IT empowerment for various institutions in Northeast. It is also clarified that the land and the buildings have solely been contributed by the petitioner from their end. In the letter dated 27/06/2009, it is clarified that rupees 2 crores utilized for purchasing the land has been solely contributed by the petitioner from their own end as their contribution. Which means, my lord, we are taking fund help, but to build up infrastructure, we are contributing, and that is our own money. The purchase of land is the money of the St. Peter's College, not the money of the NAC as projected by the prosecution, my lord. Now these are the letter, this Ames letter, my lord, and then comes the 2019 director's letter, my lord. Then also comes again the director's letter, my lord. Then again the superintendent scheme of holistic. Now comes, my lord, after all this, then comes the FIR, my lord. It is seen that in response to the last set of CBI, the director SCD have furnished point-wise clarification to a CBI, and the letter is available in nature and to the review, which is as follows. So, there, my lord, even the director in the CBI was also aware very much of the details expenditure which has been given to them, my lord. And this letter was written by UK Mishra. Now, then again, my lord, there comes page 87. The director S&T NAC under his letter dated 9 to the CBI Shillong clarified that the implementing agency, that is accused number 4 and 5, has spent more than what has been released by the NAC so far as the said letter 17/12/2009 is available at annexure to the revision petition.
Reading para 87.
85, my lord. 85. Now, my lord, here the director and S&T UK Mishra,
yes,
writes to the CBI. Actually, St. Peter's has spent more than what actually we have, the NAC has sanctioned. So therefore, my lord, now a person who is contributing land, a person who is not waiting for installment to be released, because the project cannot stop, my lord. The project cannot stop. So when the money is not coming, a person who is using their own fund, can they say that is a corrupt person? My lord, I just wanted to show, my lord, these are the outcome. I'll continue. These are the outcome of the research base, my lord. And these are the 2 volumes, and there are other volumes also, my lord. Just to show, my lord. These are the volume, the outcome of whatever. Of course, we cannot show the lab, that what themselves also have observed, what kind of apparatus, what kind of instruments, what kind of high-tech apparatus they have bought. So my lord, these are all. I will. This is then my lord. I will come to the accusations against me, my lord. Then they come to the accusation against me at page 202, my lord. 202, where is the finding where the court said that I am not guilty of the offence, my lord. Page 93 onwards, my lord. '93, my lord.
Yes.
May I read, my lord?
Yes.
Now, in respect of the accused number 2 and 3, it is also on record at paragraph 2 of page 9 of the charge sheet that financial assistance was accorded by the accused person number 1. As such, the implication of the accused person number 2 and number 3 is not justified. It is the sole discretion of the higher authority to scrutinize the project and or to approve and accord sanction, as the financial advisor has to give his own independent opinion on the project. Which means, my lord, here our job was to process the file and put up to the higher authorities. It is not within our power to sanction. The higher authorities would examine the project give its own independent justifications, and whether to the project to be accepted or not accepted, is it the job of the higher authorities, my lord. Now, paragraph 94, the prosecution has also admitted to the at page 10 that the financial advisor put up the file to the then secretary NEC, who in turn marked the same to the planning advisor for justification. It is admitted by the prosecution that accused number 2, on receipt of the recommendation of the proposal from Joint Director Higher and Technical Education Government of Meghalaya, placed the same before the higher authority. The prosecution at page 11 admitted that the planning advisor sought for opinion of one Dr. V.T. Darlong, advisor Forest and Environment, who suggested for inclusion of certain conditions. The prosecution admitted that accused number 2 has submitted his opinion that the proposal of the subject may be approved subject to suggestion given by Dr. V.T. Darlong. The said proposal was considered and approved by the Secretary NEC. Further, there is nothing to indicate that the accused number 2 and 3 has obtained any pecuniary benefits from themselves or for the beneficiary. As such, there is no prima facie case against them. On perusal of the written argument by the CBI shows that it is totally silent on the issue of charge sheet having been filed on the basis of invalid documents. That is, earlier audited statement of accounts and utilization certificates, which have been withdrawn and as such cannot be relied upon in any manner. In the written argument, the CBI is also silent with regard to the documents which has been produced by the accused persons and could not give any clarification as to why these documents have been suppressed and ignored in the charge sheet. The prosecution has a higher duty and responsibility to prove its case, but when there is a doubt in the prosecution story, the benefit goes to the accused as it is so in this case. Since it is on record that many relevant documents have been suppressed and charge sheet has been filed on incomplete documents, prosecution against the accused number 1, Shri U.N. Maji, accused number 2, R.P. Kharpuri, and number 3, Eddie Karshing, also is not sustainable, as it is apparent on record that a charge sheet has been filed on the basis of invalid documents, incomplete documents, and suppression of other relevant documents. Annexure 2, page 25 shows sanction was with approval of Secretary. There is no complaint or objection from Secretary NEC about no approval taken from him. On the contrary, Secretary congratulated the good work done under the scheme. As apparent by Annexure 2, page 27 of the Criminal Revision, NEC has clearly confirmed their acceptance on principle to the expenditure of rupees 2.67 crore incurred under the scheme pending up-to-date audit report, and also observed that the implementing agency what has been released by NEC so far. The College on 22/07/2000 submitted to the NEC the consolidated statements for the period 2203 to 5 along with remaining vouchers. Thereafter, the consolidated utilization certificate dated 29/09/2009 for the period up to 22nd March to March 2009, vide 12/11/10. As such, it is clear that the sanctioned funds of NEC has been properly and fully utilized. Therefore, it is futile to proceed with the prosecution against the other accused persons when no prima facie case has been made out with regard to misutilization of the sanctioned funds of NEC. No case has been made out with misappropriation of funds as alleged. Moreover, in view of the Honorable High Court's judgment on order dated 31/12/2000 passed in criminal case number so the charge framed against accused number 1 has become defunct. As relied upon by the defense and the case laws appeal arising Sajan Kumar versus CBI, it is established position of law that in time of framing of charge, the trial court has undoubted the power to sift and weigh the evidence for the purpose of finding out whether or not prima facie case against the accused has been made out. The court cannot act merely as a post office or a mouthpiece of the prosecution, but has to consider the broad probabilities of the case. The total effect of the evidence and the documents produced before the court any basic infirmities, etc., the court must apply its judicial mind on the material placed on record and must be satisfied that the commission of an offence by the accused was possible. At the stage of consideration of charge, the court is required to evaluate the materials and documents on record with a view to find out if the facts emerging therefrom taken on their face value discloses the existence of all ingredients constituting the alleged offence. If two views are possible and one of them give rise to suspicion only as distinguished from the court will empower to discharge the accused. So, my lord, these are the findings, the reasoning. Now, my lord, I ask a question to myself, my lord. Where is that error? Where is that error? And these documents which were produced before the trial court, my lord, were also documents which was produced, which was shown, which was annexed along with the revision petitions, my lord. The trial court has done its duty, my lord. Took so much pain to go through all the documents and find out that there is no prima facie case of corruption or misappropriation of the funds that has been made. And also, my lord, the sanctioning authorities, my lord, is not the officials who are charge sheeted here, my lord. Our job was to process the files. We have done the processing of the files. The scheme we thought is good, beneficial. So therefore, my lord, where is that? That is exactly, my lord, after showing 2-3 pieces of papers, my lord, when the question falls from my lord, what is the law? They sum up their submissions. This speaks volume on the conduct of the CBI, my lord. Therefore, my lord, in my humble submissions, my lord, this revision petition merits no consideration at all, my lord. Respondent 1 and 2, my lord, I raised my submissions. There are some citations which I am not burdening my lord with by reading those submissions. It's there, paragraph numbers are there, the page numbers are there, my lord. That's all, my lord.
I think as the same thing I've requested the petitioner.
Yes, my lord.
Also, file your
yes, my lord.
synopsis of your.
Yes, my lord. I have I just put some points.
Argument, yes.
Yes, my lord.
Public form and the authorities we are relying.
My lord, I'll do that, my lord. Oblige, my lord.
Please, Lordship. I am representing respondent number 3, and in fact, Mr. Yogin has argued the case on my behalf also.
You are
number 3, Lordship. Sri Albert Kharsing.
Yes.
He was a extension officer. The allegation against him that he hurriedly put up the file and he acted in contravention of some rules. For that reason, submission advanced before the trial court, I can see from page 28, para 28, 171. Page 171. This is the impugned order that was under challenge before the Honorable Court. It says, it's very long.
Where's the relevant portion as far as
relevant submission? What was the allegation against me? It is there. It says, in counter to the charge of the prosecution.
Para
28.
28.
Yes. Because I'll not read because the judgment was read by all the counsel again and again. Para 28. In counter to the charge of the prosecution, defense counsel Sri Richard Patrick Karpuri and Sri Albert Dor Kharsing contended at page 9 of the charge sheet. It is alleged that the accused number 3, Albert D. Kharsing, recommendations for the approval of the scheme of accused number 2, Richard Patrick Karpuri. Total disregard of Rule 149. The General Financial Rules 1963, correspondings 209 GFR on a lump sum calculation without financial break, and further it is alleged that no proper technical scrutiny has been conducted before recommending the proposal, which is in violation of the instruction B. The Government of India, memo number so and so, argued the pertinent to question to be looked here if the aforesaid accused has the power and the jurisdiction to accord financial sanction to the said proposal, that it is on record at page 910 on the prosecution admitted the financial advisor accorded the financial concurrence on 21/2/2005 for the estimate cost of project of the first installment. The financial advisor, according to the prosecution, accorded the sanction in gross violation of the financial rules. The charge sheet has alleged that accused number 2 and 3 made a recommendation without going through the contents and details of the project report, but the pertinent question is whether the dereliction of duty is the ground for criminal prosecution. Because they say I'm an officer, extension officer, there may be a dereliction of duty, but I don't have any dishonest intentions to accord the, because I was not the authority to accord the sanctions. I was just to put up the file only. It is also on record, para 2 and 9 of the charge sheet, the financial assistance accorded by the accused number 1, as such implication of the accused number 2 and 3 is not justified and is illegal. It is my submission before the learned trial court, which I advance.
What is your designation?
Extension officer.
What is your role?
My role is just to put up the file only. My role is not to accord the sanction or grant sanctions, just to put up the file to the officers. And the officer before whom the file was put up, who accorded sanction, was not an accused in this case. Defense submits that accused number 2 and accused number 3 has only discharged the duties for processing the project. It is up to the higher authority to scrutinize and project and to approve and accord sanction to the financial advisor has to give his own independent opinion and project. That 29. That is my role. That is my role. My role is to process the file only, nothing else.
Yes.
Then we relied some judgments, para 30. The defense relied an apex court decisions at para 44, 45, 49, 47, 49, 55, 2009, 817. It says that mere violation of rules where the higher authority is to give the independent judgment and sanction, there is no prima facie case under section 120B 420. This is judgment. Again, we said in 31, the defense submit mere violation of financial rules. The government circulars in the absence of dishonest intentions. The court cannot frame charge by placing burden for proof on the accused persons held at apex court in AIR 1996 SC 3390. They are saying that under section 239, 237, the accused cannot be discharged. So this is the judgment cited by the Honorable Supreme Court. It says that, what is my role? My role is just to put up the file. Then the prosecution admit in para 32, page 10 of the financial advisor put up the file to the then secretary NEC, who in turn marked the same to the planning advisor for justifications. It is admitted by the prosecution that accused number 2, on receipt of the recommendations of the proposal from the Joint Director Higher and Technical Education, Government of Meghalaya, placed the same before the higher authority. The prosecution has admitted that the planning advisors sought for opinion 1 VT advisors forest environment and suggested for inclusion of certain conditions. The prosecution admitted accused 2 has submitted his opinion. The project may approve subject to the suggestions given by so and so. The prosecution admitted. This is the prosecution's admissions everywhere. Now, paragraph 35, in the instant case, the accused number 2 and 3 had carried out their duty to process and recommend, and duty and responsibility to accept the reject is at the hand of the higher authority. Being such case, it is apparent on the face of the charge sheet the accused number 2 and 3 had no power to grant sanction. This is very important because I don't have any power with me. My power is only to place the file before the higher authority. The decision making authority is the higher authority. They will take a decisions. How can I be accused person in this case unless they can show?
You see, that is the material. The point is only if there's a connection as far as collusion is concerned.
Collusion is concerned.
Conspiracy is concerned.
That is court is not found. They have not placed any documents. The first thing is the beneficiary. Whether I am the beneficiary of anything. there is no documents placed by the CBI before the court to show that I am benefited in any way.
You are a government official. How can
Government
you-
officials. It is not there. Only the allegation is that I acted hurriedly, I put up the file. But the taking decision is not in my hand. It is the officer who has to take a decision and who had taken the decision. That they are not the accused in this case. I am the accused. I am the external officer. I process the file, I put up before the higher officials. So for that reason, the court found two grounds. Court said there is nothing to show that there is a pecuniary benefits, any benefits which I derive out of this transactions.
Where is that?
Here I'll just read again. Para 36, because it's very page 15 of the charge sheet, point 10. It is admissions for the prosecution. The accused number 2 has left the NSC. There is no case. And then charge 7, charge sheet at page.
Where's the use? Just now you said that court has observed that there is no pecuniary
Yes,
benefit.
it is lastly in the findings only. While discharging the accused person, that is the findings of the court.
That is generally to all the accused or only to you?
It is, I am the number 3, I am the extension officer. I just process the file and put up the file before the higher authority who has passed the sanctions. That is not in my hand. If I come to page para 80, para 80 is the findings. Having heard the submission of the parties and perused the record of the case as well as the document annexed above, mention criminal revisions petitions. Document produced by the accused number 2, 3, 4 and 5. It is seen that the St. Pete College submitted the project report to the NEC on 8/2/2005. The said project report 8/2/2005 is available.
Mr. Yubin has already read this.
This is already read. So
You point out only what is relevant to you.
the relevant is that, Lordship, in the judgment, the court ultimately found that I am just a extension officer. I process the file before the court, and there is no record to show that I derive any benefits of this. And for that reason, the court has said, in case of discharging the accused persons, though under section 239 CRPC says if the charges are groundless, but Supreme Court says, the judgment which I am relying, if two views are possible, one views in favor of the accused person, one views in favor of the prosecution, even at the stage of framing of charges, if the views taken can be taken in favor of the accused person, on that ground also the accused can be discharged. The two judgment which this is the judgment which I relied here also, and this is the judgment. Page 94, no? You can. No, see, before I just come to, because the relevant para-code was asking, is para 93, I'll just read. It is a page 202, before I cite my judgment. In respect of the accused number 2 and 3, I am 3. It is also on record at paragraph number 2 and 9 of the charge sheet. The financial assistance was accorded by the accused number 1 as such. The implication of accused number 2 and 3 is not justified. It is the sole discretions of the authority, higher authority, to scrutinize the project and to approve and accord the sanction, as the financial advisor has to give his own independent opinion in this project. Now, my case comes. The prosecution has also admitted at page 10, the financial advisor put up the file to the then Secretary NSC, who in turn marked the same to the planning or advisor for justification. It is admitted by the prosecution that accused number 2, on receipt of the recommendation of the proposal for the then joint directors higher technical educations, the government placed the same before the higher authority. The prosecution at page 11 admitted the planning advisor sought for the opinion of the Dr. VT Darlong, advisor forest, environment, who certain conditions, the prosecution admitted. The accused number 2 has submitted his opinion and proposal of the subject to be approved, subject to suggestion given by Dr. V.T. Therefore, the proposal was considered and approved by the Secretary NAC. Further, there is nothing to indicate the accused number 2 and 3 obtain any pecuniary benefits for themselves, for their beneficiary. As such, there is no prima facie case against them. This is the finding against me. That is I have a very, very limited role, and on that role, the court found that there is no prima facie case. It will be wastage of time if you frame the charge against the accused person 2 and 3. There is no prima facie case. This is my case, and the court has taken the view that in case of discharging the accused persons, there cannot be meticulous examination of the records. But if on the record evidence produced by the prosecutions, on the basis of that, if the inference can be drawn, if the views can, there's two possible views are available. In this court, the court has found there are two views possible. The views is favorable to the accused person to be accepted. For that reason, the relied proof judgment, which I have already cited.
What's the judgment?
This is 2008-10 SCC 394.
2008-10 SCC?
2008-10 SCC 394.
Para? Yes, what is the relevant?
Just coming. There's one more judgment, 2009 8 SCC. No, here also is.
First, you deal with this 2008.
2008, yes. Yep, 16 Lordship. It is tried the words not sufficient ground for proceeding against the accused appearing in sections postulates exercise of judicial mind on the part of the judge on the facts of the case to determine whether the case for trial has been made out for the prosecution. However, in assessing this fact, judge has the power to sift, weigh the materials for the limited purpose, whether or not a prima facie case against the accused has been made out. The test to determine a prima facie case depend upon the facts of each case, and in this regard, it is neither feasible nor desirable to lay down a rule of universal applications. By and large, however, if two views are equally possible, and the judge is justified that the evidence produced before him gives rise to a suspicion, only as distinguished from the grave suspicion, he will be fully within its right to discharge the accused. At this stage is not to see whether trial will end in conviction or not. The broad test to be applied is whether the materials on record, if unrebutted, make conviction reasonably possible. This is the page 16 in 2000. Two views possible. There is the materials placed before the. So here the court, the learned trial court, has drawn basis that the evidence produced by the CBI before the court, whereby the two views are possible, and on the basis of that, the court found that there is no prima facie case against the accused person, and the accused were discharged from the liability of the incident case. Apart from this, Lordship, the power of the revisional court under Section 397, as read upon by my friend Yobin, it is a relevant judgment because it has a very limited scope to interfere with the findings of the trial court. Because court is not going to substitute its own opinion because it's an elaborate judgment passed considering all the records placed before the court. So I humbly pray that the order passed is very much correct. It is not suffered, it doesn't suffer from any illegality, any perversity. It is justified orders, and the discharge of the accused person, correctly accused person was discharged from the liability in the same case. I conclude.
May I please, Your Lordship, on behalf of Respondent number 4 and 5. My previous counsels have already read the impugned judgment. My Lord, here that impugned judgment was passed on an application filed under Section 227 of CRPC. Now, Section 227, if I'm allowed to read you, discharge. If upon consideration of the record of the case and the documents submitted therewith, and after hearing the submission of the accused and the prosecution in this behalf, the judge considers that there is not sufficient ground for proceeding against the accused, he shall discharge the accused and record his reasons for so doing. This section as such do not specify which are the documents. If upon consideration of the record and the documents submitted therewith after hearing the submissions of the accused and the prosecution. So in general parlance, it was that the documents which are submitted by the prosecution along with the FIR, along with the charge sheet. Those are the documents will be on record as on the date of this stage of defense. When we checked the record, we found that lot of relevant documents, which are important documents, which were seized by CBI, were not produced or filed along with the charge sheet. And we were confident that if those documents were filed before the court, we will be able to prove that prima facie there is no case against us for us to stand the trial. But the court below rejected our petition, earlier petition on 90. We had filed petitions under section 91 for asking the CBI to directing the prosecution to produce those revision, and this honorable court, after hearing at length whether at the time of frame the documents submitted by the accused can be looked into or not. And after that, this court, after hearing at length and going through the supporting case laws, was satisfied and passed that order that corollary of the answer is that the trial court shall look into the documents mentioned above and also the documents annexed to the revision petition if not suspicious at the time of consideration of the charge or at the time of consideration as to whether or not prima facie case against the present petitioners has been made out. The accused petitioners are to place the documents mentioned above and the documents annexed to the present revision petition before the trial court at the time of consideration of charge. This honorable court, which was passed on the revision petition that we filed for rejecting out. This order has not been challenged by CBI at any point of time.
That is, what is the order, date of the order in?
This order is dated 31/12/2013, 31/12/2013, passed in criminal application 17 and 18 of 2013. Pursuant to that, as per the liberty and direction of this honorable court, we file all those documents on which we were relying upon including the two learned colleague has shown. Those are the, in fact, 3 volumes were research documents were taken out of this project in connection with the work done in this project. Now, Your Lordship, the whole issue is in connection with the money which was sanctioned by NEC for an ongoing project. It is not that this project was started only with the fund which has been sanctioned by NEC. This was an ongoing project, and most remarkably, this was not only pertaining to the state of Meghalaya, it was also at the same time in the state of Assam and Arunachal Pradesh. And this was just a part of the money which was sanctioned. Now, a preliminary investigation was done. Basing on that, FIR was filed. And after the FIR was filed, Your Honor, the allegations in the FIR, that FIR is in it is in the court's record, lower court's record, it is marked as flag E. Here.
That is the
Flag E FIR is 8 May 2009 is the FIR, which is flag E. In criminal revision petition 713, it is there, annexure 4.
criminal.
It is in the criminal revision petition. It is annexure 4 at page 28 and 28 to 36.
Criminal revision petition dated number
18, 17 and 18. There were two.
Oh, that was 17.
17 of 2013.
Yeah.
17 of 2013, flag E. Or it is also in a flag E in the lower court's record. In the entire court's record. Your Lordship, basically the allegations which were levelled in the FIR
yes,
was that the alleged that the full amount which was sanctioned by NEC could not be disbursed to St. Peter's College because the required conditions were not fulfilled by the principal of St. Peter's College, and further the institute was not being able to provide such technical education as college was not having sufficient infrastructure. These were totally vague allegations, because the which required conditions not met, were not fulfilled, nothing is mentioned. And infrastructure development, in fact, is, I will take Your Lordship to that sanction, the project report, project which we submitted. Infrastructure development was one of the components for which the fund was sanctioned. So that the in the FIR, that allegation that institute was not being able to provide such technical education at college was not having sufficient infrastructure, prime requirement of as per NEC scheme. Under the scheme, infrastructure development was one of the component. It has to be carried out. So this allegation is totally baseless. Then there was no forwarding letter from St. Peter's College and a proposal not forwarded by Higher and Technical Education Meghalaya, which is totally contrary to the record, Your Lordship. Firstly, the scheme was for 3 states, as I have stated, Your Lordship. However, the Department of Higher and Technical Education, Government of Meghalaya, by their letter dated 28/2/2005, which is annexure A at page 17 of the rejoinder, forwarded this letter, forwarded the scheme. And even the forwarding letter of principal of St. Peter's College, annexure 1, page 16 of the revision petition, Your Honor. If Your Honor, Lordship has got the revision petition 17, which is flag E, of the lower court's record. Criminal Revision 17, which is flag E.
Yes.
If your lordship will kindly turn to page 16.
It is a miscase.
Page 16, your lordship. This is our forwarding letter to secretary, our project proposal.
Oh, yes.
Page 16, 8 February 2005. This has reference to our various discussions during the last year and also during regional planning level meeting conducted by you in your office on this issue. We had discussed at length the matter with Secretary Planning Commission, who agreed to the establishment of ETF under NEC. As such, we are formally submitting an advance copy of the above proposal covering certain parts of Northeast at a total estimate of so much. And we already initiated the above program at Arunachal Pradesh and making advance expenditure from our own sources. We hope that the same would be reimbursed and in anticipation of NEC sanction. Now, at page 17, 18, the detail of the project.
Yes, ma'am.
What are the current activities going on and sustainable, what are the other thing will be taken out, and at page 24 the financial breakup.
Yes.
Upgradation of lab, built up space, research and infrastructure development. The breakup of the thing has also been shown.
Yes.
Field studies, laboratory analysis, capacity building for alternative livelihood training centers. Socio-economic surveys for upliftment, protection works, spatial requirement, which is obviously space will be required, your land will be required. So initially the understanding was that land was also a component under this. So accordingly, from the money that which was sanctioned, college had purchased land and building. But when it was disputed that NEC said land is not as a part of the component, though it was clearly mentioned infrastructure development and spatial requirement was one of the component. But we did not want to go into controversy with the land was not the if it is said ki land is not a part under the not covered under the for project sanctioned money, then whatever we have spent in the land will be our contribution. And the money which it is only a matter of money has been spent and vouchers were there, but the money which we put in, that is from our pocket. And the other money which we have given, we will give for that we will show the other expenses which is covering the entire money which has been sanctioned. And accordingly, your utilization certificate and audited statement of accounts were also submitted. Now, there is an allegation that it was not with the money was sanctioned not without the approval of the page 75 annexure 2 page 26 here. Here it is, see page 26, my lord.
26 of what?
Of that criminal revision only. This is annexure 2 of the criminal revision. All these documents are since it is marked already enclosed here, it has not been separately filed. This is the sanction order.
Page 26.
Yes. 26 or 25, my lord, maybe there are two numbers. Secretary NEC in exercise of the financial power.
Page 25.
Yes, authorized by the Government of India, Ministry of Home Affairs, by their letter has accorded administrative approval for implementation of the scheme. Research-based holistic cluster approach at grassroots level for sustainable development in North NER by St. Peter's College at a total estimated cost of rupees 4 crore 98 lakh something. The sanction is subject to the following terms and conditions. And then they have given up what it is there, separate inventory of all computer items, software, laboratory. So this clearly shows that this and the first installment was released by this order. This clearly shows that it was with the sanction of the secretary. But in the FIR there was an allegation that it was done without the sanction of the secretary. The amount was approved and sanctioned. Then guidelines not followed is another allegation in the FIR. The conditions highlighted by Dr. V.T. Darlong, advisor Forest, were ignored. This allegation is totally vague. Which guideline, whether it is financial guideline or whether it is a guideline, which guideline has not been followed, There is nothing, just a vague allegation that guidelines are not followed. The suggestions of DT Varlong for appointment as an advisor of nodal agency was duly considered and Nehu was appointed as the nodal agency. If your lordship will go to Annexure P as page 106, there is a rejoinder affidavit also. Oh, yeah, sorry. In rejoinder affidavit is at flag F. Your lordship may note down the only the flag, relevant flag. In my written argument, I have given everything mentioned here, which I'll
Flag F of this.
Flag F. Flag F is the rejoinder. So I will be confining to flag E and flag F because all the documents are in this too. Flag E and flag F only. Rejoinder affidavit will show at the last page of the rejoinder affidavit. It shows that NEC to the Vice Chancellor this letter.
Yes.
Nehu requesting to evaluate the work at the earliest and submit the report. I mean, your lordship, at the time of filing the FIR, when the project was just started, evaluation cannot be done at that stage. Evaluation has to be done only after a sufficient major portion of the work is completed, and after that only a body will evaluate. Otherwise, the moment the money is sanctioned, what is to evaluate? So, Vice Chancellor Nehu was requested to do the evaluation. This letter shows that that is also an allegation in the FIR. False audited statement, rupees 35 lakhs released to Muse, which existed only on papers. Here is the point, Your Honor. I will show your lordship that our application and the documents by which we submitted the detailed accounts, audited accounts, a detailed statement along with all original vouchers which are submitted to CBI during the course of preliminary investigation. But they ignored those documents, and in the FIR also, in the FIR it is written that they were released to Muse. All these documents were submitted even before the trial court at volume M1, M2, which contained the entire original vouchers of Muse. Because this project was done by St. Peter's in association with the NGO, Muse. The entire audited statement, which were, but it has been suppressed by CBI while submitting the.
You're reading which part? This
is from the FIR. I am showing that allegations, Your Lordship. St. Peter's College purchased the land, which I've already mentioned that this the spatial requirement was a part of the component, was a part of the sanctioning order. But however, subsequently, since it was disputed that the land is not covered, so that we have set cases for. In contention is that there is plus. This is the finding in the charge sheet. But charges are framed under, it is misappropriation of money. They have not come to the conclusion that there is forgery, there is cheating, nothing of that sort. Only that there is misappropriation of, though college has spent more than the sanction amount released, but even out of the amount which has been released, from there, it appears there is no proper voucher and all that. There is misappropriation to the tune of 1 crore plus. That is the finding in the charge sheet. That is the finding. But charges are asked to be framed under what? Charges are framed in the charge sheet 120B, 420 cheating, 467, 471. Forgery, whereas there is no finding in the charge sheet about forgery. If there is misappropriation of money, what is the proper section under which the charge should have been framed? After all the preliminary investigation, you come to the finding that there is only misappropriation to the tune of 1 crore. Have you framed any charge for misappropriation of money? And then under PC Act, Corruption Act you have given, but so far as 4 and 5 are concerned, we are private individuals, not covered under the PC Act. And so for other charges that you have framed, that is, there is not even the slightest ingredient of those charges which were present or which were found during the entire investigation, and even in the charge sheet, the conclusion is that there is only misappropriation. So this kind of charge sheet, whether it will stand in the eye of law. Now your lordship will come to the moot point. Our whole case is that we submitted utilization certificate, 3 utilization certificate, as and when the amount were released, utilized, and subsequently when the land matter was controversial and we said it is from our thing, and we withdrew that utilization certificate on 6th May 2009. And NEC also directed us that we must file a consolidated utilization certificate. Now the question comes, 09 we withdrew all the 3 utilization certificate. 8 May 09 FIR is filed. 11 July 2010 charge sheet is filed. At the time of filing the charge sheet, whether CBI was aware of the fact that on 6th May 09 we withdrew the utilization certificate. That is the main point here, because our case is the charge sheet is based on invalid document and insufficient material. This is the 2 points that we urged before the trial court, that it is based on invalid document and insufficient material. Invalid document because in their affidavit before this honorable court, even before the trial court, CBI stand is that they have clearly, categorically, they have taken the stand that we have filed a charge sheet based on this 3 utilization certificate. Now our case is that these 3 utilization certificate stands withdrawn, which is no longer in existence. Can it be acted upon or be framed on those invalid documents which are no longer valid, which already stands withdrawn and not in existence. So it is based on invalid document. It is there admitted. I will read out their affidavit filed before this court. And insufficient document. Now whether question is CBI knew the fact that at the time of filing the charge sheet on 10th July 2010 that this utilization certificate stands withdrawn. Whether they were aware about this letter of 6 May 509. Your Lordship, in our petition before the trial court, we specifically mentioned about this letter, which was seized by CBI. And we
withdrawal of the UC.
Withdrawal of the UC. And we requested the honorable court to direct CBI to produce this document before. What was the intention of CBI? What stopped them from producing these documents which stand seized by them? Your Lordship, I will take your Lordship to that particular petition. This is along in flag F with my rejoinder. We have enclosed that petition. Annexure, I don't know what will be L, page 93 of flag F, Your Lordship. Flag F is the rejoinder in criminal petition 17 of 2013. Page Annexure L. This is a petition filed by us before the special court.
Yes.
An application submitting certain documents in support of the case of the accused persons with a prayer for calling the original copies of the same, which were seized by the CBI during investigation and are lying either with them or with NEC office, and also praying for calling other related documents and certificates from NEC relating to the case which were submitted but have not been made part of the documents relied by the CBI. Pick and choose manner, CBI has enclosed documents along with the charge sheet and filed before them. You cannot do that, Your Lordship. What is your motive? What is your malafide intention in that? CBI, being a fact-finding authority, must play a very unbiased role. They are only to assist the court to place before the court what is the facts. They should not have the intention, or they should not be desperate that just because the FIR is filed, we have to prove a case, whether or not the complainant is having any other grievance against the party. What my colleague has also submitted, that CBI has played a very not of what is expected from an agency of like CBI. Now, in this petition, Your Lordship, you will see under clause 14-15. In clause 15, we have clearly written, letter dated 6509 from P. Tharos to Director S&T NEC on the subject of withdrawal of utilization certificate may be called from NEC, or same is enclosed and marked as M24. So this already original was seized by CBI, which shows that it was within their knowledge that these utilization certificate have been already stands withdrawn. But in their affidavit in opposition, which is annexure flag G, Your Honor, filed in this criminal revision, where annexure G, CBI has taken a clear stand that in the aforesaid context at para 6 of their affidavit in opposition, my lord, this is flag G.
Yes.
Flag G, affidavit in opposition filed by CBI before this honorable court. In the aforesaid context, paragraph 6 of the affidavit, as stated in para 5 above, the deponent submits that CBI submitted a charge sheet on 30th July 20 against the petitioners and other accused persons on the basis of following utilization certificate submitted by the petitioner accepted by NEC and which was seized by CBI during investigation. So they have based only on these utilization certificate. Utilization certificate.
You have not page marked this?
Paragraph 6, para 6 of their
Para 6.
affidavit, my lord.
Page you have not given.
This will be in the flag G of the document.
Flag G, no doubt.
Flag G is it the affidavit in opposition?
Yes, flag G is here.
Yes, my lord, page internal page 4. I think there is. This is filed by CBI. I don't know. They did not mark the page. It's page 4, paragraph 6. Their internal page 4 it will be of the affidavit.
Yes.
Para 6. That in the aforesaid context, as stated in para 5 above, the deponent submits that CBI submitted the charge sheet on 30th July 2010 against the petitioners and the other accused person on the basis of the following UC submitted by the petitioner and accepted by NEC and which was seized by CBI during investigation. So their entire charge sheet is based only on these three utilization certificate. UC dated 15/6/25, UC dated 26/7/25, and receipt and payment accounts 27/3/28. Now all these three stands withdrawn via our letter dated 6/5/09, my lord. So the entire charge sheet is based on invalid document and insufficient because CBI could have waited, knowing the fact that this stands withdrawn.
See,
so whether
the allegation against you is knowing fully well that you have
withdrawn.
No, not that you have withdrawn. Knowing very well that the case or investigation is going against you, so you have withdrawn.
That is now they are saying during the course of submission. Now they are saying that is not their stand. Anywhere they have not stated that. Anywhere, nowhere they have stated that we no. How are we supposed to know when CBI is going to investigation is going on against us? Obviously, I cannot have any sort of connection with CBI. Now, investigation is going on, and as I submitted on the last occasion also, the work is also going on. There is no stop. You cannot do it. All these writings, all this asking by NECs also from time to time, even during the preliminary investigation, we were asked to submit this report, that report, total status report, progress report. That was going on. There was no stay on that key. Preliminary investigation is going on. Any work in connection with the project has come to a halt. It was not like that. There cannot be any correspondence. There cannot be anything to do with this. Preliminary investigation is going on. It was not like that, Your Lordship. Even when the preliminary investigation was going on, under the project was carried. NEC's letter was there, certificates were there, all those were there even during the period of preliminary investigation. How are we supposed to know when CBI is going to file the FIR? It is not to our knowledge. After that, because we were clean and we were confident that since we have not committed any mistake, no FIR, it was on a basis of a complaint of somebody, their investigation is going on. But we knew that there is nothing against us because we have not done anything wrong. And only on 6th May 09, it is not that key. In that case, Your Lordship, even controverting that land is not a part of the under the scheme, which NEC, that means NEC had some conspiracy with CBI to initiate the case. Why, even after that special requirement being mentioned in our proposal, even in the sanctioning, why subsequently they disputed? So we have been we are the victim in that case. In that case, there has to be some conspiracy between NEC and CBI to victimize us, because once that was already part of the sanction, and obviously, so the understanding, it was understood that when special requirement was one of the components for which the project was proposed and sanctioned, accordingly it was spent. Now that subsequently NEC controverted that, we cannot say we were part of that chain along with CBI. I'm sure it was not that. NEC on their own day controverted, and that is why we required to withdraw the utilization certificate. Not what CBI now trying to make out a case that now knowing that the investigation is going on and we are scared and so we have withdrawn. It is not that. What compelled us to withdraw? Because NEC controverted. If that is their stand, then it can say that the inference has to be drawn that it is a conspiracy between CBI and NEC. So we were not knowing when CBI is going to file the FIR, and that at all FIR will be filed against us. We withdrew because NEC controverted, and then we said land is our component, our contribution and thing from our money, and so it is only a matter of accounting.
I think this was done not before filing of the FIR, filing of the charge sheet.
Before filing of the FIR. 6th May we withdrew. 8th May FIR is filed. So we didn't know that FIR will be filed, because we were clean in our dealings, in our conduct.
Yes.
Now at this stage, if they say, oh, they got scared and that is why before that they withdrew. And by withdrawing, how it is helping us? It is your conduct while doing the investigation. What stopped you when, in spite of a clear direction from the Honorable Court, that you produced all the documents? Why CBI had to adopt a pick and choose method? Documents which are in our support, you suppress, don't forward it before the court. Document which already stands withdrawn, an invalid document, basing on that, you try to make out a case and forward that before the court. And when all these documents were placed and each and every document was read out and taken note of by this Honorable Court, the court was satisfied. And that is why this Honorable Court directed that let these documents also be placed before the court. Now in 227, why that provision has been made, Your Lordship? If there is sufficient materials which shows that prima facie there is no case, and any FIR is initiated on the basis of some grudge or on some frivolous ground, whether an innocent litigant should be made to suffer by going through the lengthy trial. And keeping that in mind only, the legislature has kept that provision of 227 when these documents are, if sufficient materials are there and can be found prima facie that there is no case, can be discharged. And the exercising that power by the trial court, by the special court, I will not burden this Honorable Court now again by going through the impugned judgment which has already been read out. It shows clearly in an elaborate way, the trial court has gone through the entire materials and then found that yes, these documents which were not earlier, which was not forwarded by CBI, after going through those documents, yes, there is no prima facie, court was satisfied that no prima facie case is made out for standing the trial, Your Lordship. Because whole allegation was court has to frame a charge. Whether on the basis of the charge sheet which was filed based on invalid document, could trial court frame a charge? That's, we have submitted, now CBI stand is that so far as the present accused persons are concerned, as per the requirement and as we committed that we withdrew these 3 utilization certificate and we are filing a consolidated utilization certificate, we submitted that much before even the charge sheet was filed. 22nd July 2010, we submitted the consolidated utilization certificate audited statement of accounts to NEC. Now we do not know for what good NEC did not forward it to CBI. That for that we are not to be blamed. Nothing can, no inference can be drawn on our part, no conspiracy. If there was conspiracy between the petitioner and NEC, first of all the case would not have come up. NEC would not have controverted the land matter, which has led to all this withdrawal of utilization certificate. If there was at all conspiracy, what the CBI counsel on the last occasion tried to place before this honorable court, impress upon this honorable court that there is conspiracy and correspondence between. If conspiracy, CBI would not have controverted the land element. Because element we had to withdraw the utilization certificate. And because we withdrew the utilization certificate, now you are drawing an inference that you are guilty, we are in conspiracy. If there was a conspiracy with us, with NEC, then the utilization certificate, consolidated utilization certificate as asked by NEC, which we submitted and which contained everything, along with the audited statement of accounts, which we forwarded to NEC on 22nd July 2010. Why was it not forwarded by NEC? Because investigation was going on at that time also. Why NEC did not forward it to CBI? That see, they have already submitted a consolidated statement, utilization certificate. This is the correct one. Now we do not know whether from this letter we see subsequently that CBI, NEC forwarded to CBI after framing of the charge sheet. Now, so far as accused number 4 and 5 are concerned, we do not know whether it was with some understanding with CBI it was not sent, or it was bona fide mistake of on the part of NEC that it just remained. We do not know. We are not privy to all that. If there was anything, any conspiracy with them, and I do not want to bring any allegation also to that extent. But so far as we are concerned, we have submitted, and charge sheet was filed thereafter. So
I think in course of proceedings,
yes, my lord,
you have referred to the NEC letter.
Yes, we have subsequently submitted affidavit where your lordship.
I think
these are also met in my.
That was the recent development.
Recent development. What has happened? There is an instruction from the central government.
The completion of the
yes,
of the project.
That projects pending for more than 10 years should be closed.
Oh, yes.
Okay. And one more important thing, your lordship, that relevant paper and see. As per the procedure of government grant projects, these have to be sent to AG. Now, we have been informed by NEC that on 2nd May 2013, my lord, this is Annexure O, page 105 of our rejoinder, flag F. Flag F, Annexure O, page 105.
Yes.
Here, NEC is informing us. M. Iboyama Maite, Advisor, Horticulture director, he is not an accused. So there cannot be any conspiracy or conspiracy cannot be drawn with him. He has written to us on 2nd May 2013, acceptance of UC and audited statement accounts against the ongoing project. This has a reference to your letter under the above subject. Although the UC and audited statement of accounts was prepared by the competent chartered accountant of your choice within GFR provision, a copy of the same has been forwarded to the Office of the Principal Accountant General Meghalaya on 9/12/2011 following their queries about the status of the project and details of expenditure. This office has since not received any further queries or objection from the Office of the Principal Accountant General Audit Meghalaya. If there was any such serious lacuna or misutilization or any such serious defect or anything, then even from the AG's office also some observation would have come. There was no such objections or observations even made by from the Accountant General Office, which is one of the requirement if under the government sanctioned project. Now there is with that, Your Lordship, we filed an affidavit before this Honorable Court on 28 August 2023. An affidavit bringing documents on record for closure of the instant criminal revision.
Criminal revision?
This we have filed on 28 August 23 affidavit filed by us.
Twenty-eight,
28/8/2023.
Yes.
Your Lordship got it?
Yes.
My Lord. Annexure 1, if Your Lordship will see, this is a letter dated 16 March 2017. Where the last paragraph, last two paragraphs, Your Lordship.
Yes, ma'am.
Second paragraph, if Your Lordship will see. However, during the review meeting held under the chairmanship of Secretary NEC on 23rd February 2017, a decision was taken that projects which have been delayed for more than 5 years from the date of scheduled date of completion to be closed on as is where is basis. Further, it was also decided that any leftover work from the sanction scope are to be completed by the state government from their own resources. Though the implementation of the project on holistic cluster approaches at grassroots level for sustainable development of NER has been quite satisfactory, it is within the purview of the decision as it has delayed for over 10 years. Accordingly, it is requested to facilitate closure of the project, submission of report and declared closure certificate. Exploring our own other funding resources for completion of any leftover work from the sanction scope.
This is since 2017.
2017. Yes, my lord. Then closure of this. Then we submitted in 2023. Closure of the project, Annexure 3. With reference to that letter, my lord. As desired, kindly find a requisite follow-up for closure of the project and provision of necessary documents as stipulated in your letter. St. Peter's College has since facilitated for project closure in as far as NEC funding is concerned. One detailed voluminous report of the project R&D environmental study outcome has already been furnished during August 2007, which was acknowledged by Secretary White letter dated 29 August 2007 and 6/9/2007. In addition, kindly find progressive soft copies of Volume 2 and Volume 3 project environmental study reports reflecting the survey, investigation and R&D outcome along with tribute video. Utilization certificate for the operational period against a cumulative release of 2.67 crore has already been furnished as evident in the above. Then declared closure certificate is enclosed, and it is clarified that R&D based activities through its higher secondary section from its own resources even after the discontinuation of NEC funding with several findings outcome reports. Your Lordship, this is a project closure report, so far as finding out the NEC is concerned. Here also, Your Lordship, we have also enclosed Annexure 5. That was a letter issued by Director NEC to the principal, kindly refer to a letter dated 2nd August 2007, acknowledged receipt of one copy of the research-based holistic approach to sustainable development in NER. After submission to Secretary, the same copy was forwarded to Chief Conservator of Forest, NEC. In the meantime, the Service and Technology Sector of NEC Secretariat has come to know about these research-based documents, which they value much and relevant for their sector and desire to have a copy for their study and custody. It is in this context I request you to kindly arrange to provide another copy if possible for you. So this, they have appreciated the work. Can I have those 2 volumes? And again, Annexure 4 also, if your Lordship will kindly see. I have been directed by Secretary NEC to thank you for the research-based holistic approaches to sustainable development in Northeastern region. Secretary NEC has desired to congratulate all the staff members and the principal for the very interesting study.
Yeah, this is beside the point.
Yes,
See,
madam.
how the project has been completed, see how in what manner it was done, that is beside the point. That is your objective and you have done it. The only controversy here is the way in which it was completed. So that was the the issue raised by the CBI, that in course of your completion of the project, or
That is the whole whole thing is that but as I have pointed out, your Lordship, as I have brought to your Lordship's notice, that in the charge sheet the observation is there is misappropriation, then the allegations and the charges are cheating and forgery. So misappropriation, for misappropriation you cannot frame a charge for cheating and forgery. So technically also the charge sheet which is filed by CBI is defective. And on top of that, your Lordship, CBI in the affidavit has clearly stated that they are relying only on these 3 documents. Whether a charge sheet, can anybody be charged for on the basis of something which is invalid?
Is there any observation in that regard in the impugn order, as far as the technical part is concerned?
Not in so many words, but then it is obvious, your Lordship.
No, it's obvious. To you it's obvious, but whether that has been brought to the notice of the trial court and
it was,
observation was made that
yes, it was submitted. That part has been observed. That this
wrong sections of law has been...
no, that has not been noted by the trial court. But in my written argument, it was even filed before that, it is there. And this is all matter of record, your Lordship. The charge sheet, the observation is there, and the charges which has...
That has to be examined as to how it will be relevant to the final determination of the...
And more important, that is one of the part which I am bringing to your Lordship's notice. But even the main case of the CBI now, that they are relying only on those whole stand of their charge sheet is only based on those 3 documents. Submission of the document which was subsequently withdrawn, whether would have been acted upon, and they are not CBI. It is not their case, nobody's case, that this is in violation of such and such financial rules of the Government of India, general financial rule. It is in violation of that. That is not the case, your Lordship. Had it been that, when all these utilization certificate was also sent to the AG office, Accountant General's office, they also did not make any observation that this amount which has been spent from under the sanction amount, that there has been irregularities or violence of any of the government financial. So in that view, my humble submission is that, your Lordship, there is no, in fact, the exercise of jurisdiction by the trial court is not without jurisdiction, and it is also not the case of the CBI that the court acted without jurisdiction or traveled beyond its jurisdiction while passing the impugn order.
Yes.
This revision petition may be rejected. Obliged, your
Who else is there?
I have submitted my written submission, and although we'll also submit one chronological dates. Otherwise, also that is also part of chronological dates is also part of the record already in the revision.
What about the other? Have you filed your? You are supposed to file your.
It's not filed.
So you do that. Because you said that you will you rely on some authorities. What about Mr. Yubin?
I will file that. You will file also.
So we'll leave it at that.
Your Lordship, we pray that on the next hearing we may be given liberty to reply or respond to the respondent's arguments, as the learned DSGI is not present here today.
On law point, if he wants to touch anything.
That of course, law point zone is there. Except for the, yes, you do have
Your
some.
Lordship, we also pray that if the respondents could supply us with a copy of the judgments that they relied on.
Of course,
I have not relied on any judgment, Your Lordship.
You, Mr. Yubin, you give.
Yes, yes, sir.
Heard. Mr. P. Yubin, Direct Counsel for the respondent number. You're for 1 and 2.
1 and 2, my lord.
1 and 2, comma. Mr. M.F. Kurishi, General Counsel for respondent number 3 and 3, and also Ms. P.D. Bujar Barwan, then Senior Counsel, appearing for respondent 4 and 5. On conclusion of the submission made by the respective counsel for the respondent, Ms. Learned Counsel for the petitioner has submitted that since the learned DSGI is indisposed for the day, the reply of the petitioner will be fixed on the next date. Accordingly, matter will now come up after 2 weeks.
Published.
Second call from supplementary cost list, item number 9.
Where have we left off?
On the last occasion, my lord, the point of argument was this: whether CPC is applicable, the spirit of CPC is applicable or not.
As far as the review part is concerned.
As part the review part was there, and second point is this: whether if my petitioner's predecessor, father and mother, has not claimed the post, subsequently the granddaughter, can she claim the post? I have two judgments which says otherwise, my lord, and judgment of this honorable court, my lord. So before I take my lord through those judgments, I will pass it over first, my lord.
We'll take up the matter in the second half.
My lord.
At 2.
My lord.
Yes, your lordship, please.